For a session of questions and answers relating to the recently amended Irish Investment Limited Partnership legislation. This session is a sequel to our presentation last December 10th. In December, we discussed the legislation in some detail. In today's sessions, we're going to address questions that we've received from fund sponsors and others that we believe others are likely also to have. My name is John Hunt, an investment management fund formation partner of the international law firm of Sullivan and Worcester. Joining me are David Naughton, an investment management partner of the law firm of LK Shields, Brian Murphy, a financial services tax partner of Grant Thornton, Michael Humphreys, a director of Davy Global Fund Management, and Philip Dempsey, the head of Sanne, Ireland. Today's presentation is about you and your questions. If you have a question, please send it to me through the Q&A function, and I will try to work it in. Note that I will not be monitoring the chat function. Respecting your time, we're going to try and keep this session to less than 1 hour. After the session, we will be posting a video of this session as well as the video from the December 10th session. We'll also be providing a link to a presentation that will include a comparison of certain terms of the Irish Investment Limited Partnership with Luxembourg, Cayman, Delaware, and Delaware Limited Partnership. So let's begin. While you are preparing your questions, I'm going to ask David to please give us a quick summary of the law. David, what's changed about the Investment Limited Partnership law in Ireland? And what did it introduce?
Thanks, John, and thanks to everyone for tuning in this afternoon. So an investment limited partnership is a partnership vehicle established pursuant to the Investment Limited Partnerships Act of 1994, which has been rebooted by legislation enacted during December of last year. To recap on our conversation during December of last year, the amended legislation introduces the following new features of an ILP. First of all, the naming convention. You can include the ability to register an alternative foreign name in order to enable an ILP operating in a non-English speaking jurisdiction, for example, China, to have official recognition of the translated name in that jurisdiction. Limited partner protections have been expanded through the whitelist of activities, which can be performed by limited partners without affecting their limited liability status. For example, involvement on limited partner committees. General partners now have express statutory novation of assets and liabilities rights in the legislation, where there's a substitution of a general partner. There's also express confirmation of the ability to transfer a general partner's interest and provision clarifying the liability of incoming and outgoing general partners. There's also further statutory clarification on the requirements for the withdrawal of capital, in addition to a streamlined approach to the amendment of the limited partnership agreement, which is an effort to ensure operational efficiency. Finally, there's the ability to create an umbrella investment limited partnership, which would have segregated liability between subfunds.
Great. And just generally, what is an investment limited partnership? How is it different from, is there a limited partnership? Is this something special or?
Yeah, a great question, John. So there is a limited partnership under a 1907 Act in Ireland, which is unregulated. But the key point to note in this webinar, in my view, is that the investment limited partnership, or the ILP, is a European Alternative Investment Fund, an AIF, whose legal structure is a partnership. The ILP comes into existence when it's authorized by the Central Bank of Ireland, the CBI, and then is subject to a supervisory regime within the legal and regulatory framework for AIFs in Ireland. So to summarize, an ILP is first an AIF and second a partnership.
Okay. And so just some key features, can they be multi-currency?
They could indeed, absolute flexibility in terms of currencies. So effectively, the ILP is a common law structure familiar to major international sponsors, GPs and LPs. It's formed by a GP and one or more LPs pursuant to the limited partnership agreement. As I mentioned earlier, it is an EU AIF, fully compliant with AIFMD, and is within scope of other major EU laws. For example, the SFDR. It's typically eligible for investment by qualifying investors, institutional or sophisticated investors with a minimum initial capital of €100,000 per investor. And because it is an EU AIF, if it has an authorized AIFM, it can avail of the AIFMD marketing passport. It can have an unlimited number of investors, the statutory limited liability for LPs. It has minimal investment restrictions, no borrowing or leverage limits subject to disclosure, and it now has flexibility in terms of share class structuring. So you can produce a class with excuse and exclude provisions. You can issue classes at other than net asset value. You can facilitate stage investing. And finally, you can develop management share classes which participate in the ILP, receive returns which are greater than, but need to be subordinate to the returns which other share classes are entitled to. Finally, there's structuring flexibility in terms of waterfall provisions. You have the full remit of service providers, a GP, an AIFM, a depository, an administrator. And it is, of course, possible for the AIFM to delegate portfolio management or risk management to a global investment manager, either in the US, the UK, or Asia, in accordance with AIFMD and the local requirements of the CBI.
Okay. Just really quickly here, are there any kind of investment diversification requirements associated with the ILP?
Well, that's the beauty of the product, where it's structured as a QUAIF, where you have an ILP that houses...
Just to be clear, a QUAIF is a...
It's a qualifying investor, alternative investment fund. And I think, John, you've hit on an important point. Just taking a step back briefly, the ILP needs to be authorized as an AIF, either a QUAIF, a qualifying investor alternative investment fund, or a RAIF, a retail investor alternative investment fund. Now, because of the investment restriction limitations for the RAIF product, you'll see ILPs housing the QUAIF regulated fund. And to answer your question, John, there are minimal investment restrictions, diversification requirements for the QUAIF product, which could then facilitate, for example, a single asset ILP.
Okay. And any kind of minimum capital requirements associated with the ILP?
Not at the level of the ILP, no.
Okay. And is any requirements for shareholder meetings?
There are not, no, because this is a partnership structure. It is limited partners joining with a general partner in the limited partnership agreement. So there aren't requirements for shareholder meetings.
Okay. Finally, what remains outstanding? Is there anything that has to still happen? Anything that the central bank is working on that may help clarify issues?
A good question, John. The central bank has been heavily engaged in the reboot of the ILP and is very active in discussing industry concerns and clarifying matters. So, for example, clarity requires to be sought and given by the CBI on whether a general partner can be a non-Ireland company, and clarification as to whether its director is required to be approved by the CBI. We also need clarification on whether the directors of a general partner incorporated in Ireland need to be resident in Ireland. And also there is ongoing work on the application forms for the authorization of the ILP. So for example, Section 9 contains the requirements to be added to the limited partnership agreement pursuant to local regulation. That agreement or that form is currently being finalized with the CBI. So there are items to be clarified with the central bank. That work is ongoing and the central bank is engaging proactively in this process.
Okay, great, thanks. So let's, is there any kind of opening of this up to everybody? Is there any kind of, what kind of funds do you anticipate are going to be using this kind of structure? The ILP.
I'll take that one, John. It's Philip here. I think obviously they're very well suited to private equity, venture capital, real estate, real asset type funds. I suppose primarily because of the investment types that they engage in, in terms of from a liquidity perspective, and also in terms of just how it's constructed from a capital commitment perspective, in terms of use of capital accounting, which is obviously well known to the more closed-ended fund structures. Also think in terms of just having in terms of I suppose the ecosystem of service providers, it very much requires that kind of deep domain subject matter expertise to work alongside the managers and the limited partnership sponsors. So I think in terms of the really kind of the closed-ended fund space is where the ILP will probably see the most amount of traction from a manager perspective.
Do you anticipate open-end structures such as hedge funds using this kind? I mean, I say that because we use Cayman exempted limited partnerships in setting up master feeder structures for hedge funds.
Yeah, it's a really good question. And I think, John, something that you and I have discussed in the past. I think traditionally hedge funds have been set up using an ICAV, which is obviously a unitized fund structure, and it has obviously different features to the ILP, but it's certainly an interesting concept and something that I'd seen in my previous roles with Cayman structures, where you had the limited partner and for US onshore investors, and then you had for the offshore investors you had incorporated companies. So I think as a concept, it's something Ireland has all the tax advantages and benefits from a tax transparency perspective, but I certainly think in terms of looking at hedge funds, it gives managers something very interesting and different to think about.
John, just to chip in on that, I mean, I would think there is a role for illiquid strategies, but wanting to pursue effectively an evergreen type fund structure rather than a closed-ended structure. And I think we are starting to see that in areas like infrastructure, renewables, and other real asset classes, where the manager actually wants to build up AUM over time rather than have a series of vintage funds. And there are challenges to that, but the ILP should be well suited to that.
Yeah, we've been working on that for one of our clients, and the challenges of that are, how do you provide any kind of meaningful liquidity? It can be open end, but if it's not a closed end, people are going to want to know how they're going to get out of that at some point. So you're absolutely correct. It raises all sorts of interesting questions, but I agree. I think
there are challenges. Yeah, there are challenges around liquidity. There are challenges around the capital accounting, where you have potentially multiple vintages coming in at different times and when to draw them and so on. But these are challenges that can be managed. On liquidity, for example, you can draw on capital commitments of other investors, you can have liquidity facilities, and you can have sort of waterfall type provisions which result in redemptions becoming available as cash is available to do that. So usually the sale of assets is your last resort in a evergreen type structure, even when you've got fairly illiquid assets, but it can be done.
Yeah, nobody likes giving back the money.
Yeah.
Is there any kind of asset class that may not be well suited? How about things like digital assets? Any thoughts?
I think the only thought I'd just throw in there is that, for some strategies where there's highly active transactions, I don't know if the ILP is always going to be the right answer. It is a tax transparent structure, and for taxable investors in a tax transparent structure, making, with a highly active strategy, that probably wouldn't make sense. Will be my thoughts on that.
Yeah, I'd agree with Michael fully. I think what we'll see is the ILP being well suited to the illiquid asset classes, private equity, venture capital, infrastructure, real estate. Whereas I think, because of its nature as a closed-ended fund, I think, for a short-term investment strategy, maybe a bond equity asset class, I think that's probably better suited to perhaps an ICAV structure.
Is anybody aware of any launching of a new ILP under the new legislation?
Yeah, I think we're up and running, John, which is great news for the industry in Ireland. So earlier this month, I understand the 7th ILP was authorized and sponsored by a US manager, which is great news for Ireland and proof of concept right away.
We're working on an ILP under the new structure already, which hopefully will launch fairly soon. And we have an existing ILP under the old regime as well. So we have some experience of both regimes.
And just on that as well, John, yes, you know, we're also working on some potential ILPs as well. And I suppose what we're seeing, you know, in terms of our business in the US, we're seeing some of our clients now coming to us, and they may have parallel funds in some of the other European jurisdictions. And I suppose one of the benefits of setting up an ILP is you can use, particularly on the AIFM side, you can use the existing infrastructure and set up an ILP using obviously a local fund administrator and a depository here, but you can obviously use your AIFM passport from another jurisdiction. So that also gives an interesting dynamic as well for US and other managers who are looking to use an ILP.
We had a question about taxation, and is there any what are the benefits of this for purposes of taxation?
Thanks, John. I think the benefits here, I suppose, number one is if we're comparing it to other jurisdictions, and particularly to other European jurisdictions, from a pure tax perspective, there isn't a significant difference. There might be some fairly specific matters that will affect some limited structures. So again, to name them, from an Irish perspective, you simply have an ILP that is a tax transparent vehicle. And we might go into that in a minute in a bit more detail. But from a Lux perspective, which is the main competitor from a European domicile perspective in any event, the two tax regimes are very similar. They're both effectively tax transparent structures. There is, in some cases, the possibility that there is a municipal business tax applied in Luxembourg, depending on the way the structure is set up. But again, that really is something that generally can be managed from a Lux perspective. And again, I would allude to my colleagues in Luxembourg to give the specific advice in that regard. But there is
Brian, is that the tax abonnement?
Yes, exactly, John. So again, it's a consideration that needs to be dealt with. I believe in most circumstances it can be dealt with. In some, limited circumstances, it can create an issue. I think from a pure tax perspective, that's the main difference, because really both structures are traditional transparent vehicles, and as most of you will know, the transparency of the fund ensures that effectively there is no tax at the level of the Irish fund. All income that is generated at the level of the ILP is deemed to be income that is attributable to the investors or the limited partners, and the tax considerations will then be dealt with at the level of either the limited partners themselves, or indeed you will obviously have some tax considerations at portfolio level.
Now, in Luxembourg, the RAIF, there are certain benefits of electing RAIF status. RAIF status will trigger the tax abonnement, but it also gives you certain benefits under ATA D2. Is there is there something similar? Are there certain benefits under ATA D2 for purposes?
I think from a broad perspective, John, there are benefits. And again, when I think about the ILP, again, I think about the tax transparent nature as opposed to the tax opaque nature of the other key structure that we would use from an Irish perspective being the ICAV. So obviously the difference being that the ICAV being an opaque structure, you technically don't have flow-through treatment, and you do have income that is attributable to the ICAV itself. Now, from an Irish perspective, the ICAV is exempt from tax. So you end up with the same tax answer, but just in a slightly different manner. One key advantage, I suppose, that the ILP would have now going forward over the ICAV or the corporate structure is when you look at treaty access. So the ICAV itself is a resident of Ireland for the purposes of our treaty network, and specifically when you look at the Irish-US treaty, collective investment schemes, which the ICAV is one of, is specifically called out as a resident. So it is clear that the ICAV is a tax resident for the purposes of the Irish-US treaty, but you do obviously have to look further down the line in terms of treaty benefits and look at the LOB clause and whether or not the ICAV will meet the conditions there. Where it can, you do get the advantageous treatment that is accepted under the terms of the Irish-US treaty. The globally, treaty and treaty access is becoming more and more of a concern, whereas politically and from a regulatory perspective, there's a lot of goodwill around the fact that regulated funds are generally seen in a positive light from the perspective of looking at relevant from the EU authorities would be that the regulated funds should get treaty access. But particular jurisdictions are looking at this in more detail now, and with the advent of the multilateral instrument, which effectively brings a principal purpose test, like you'll be familiar with in some treaties, but to a much broader range of treaties. The question does arise in corporate structures now as to whether or not treaty access is permissible, and indeed where you have structures that are put in place. And if you quote from the MLI, the PPT states that it effectively restricts it provides tax authorities with an ability to restrict treaty benefits where one of the principal purposes of any arrangement or transaction that resulted directly or indirectly in that benefit. So if the authorities view that the use of the fund was simply to obtain treaty benefits, they are in a position to deny those benefits. That's the long-winded way of getting to what is a short response, but the tax transparency of the ILP means that you do not need to consider whether or not you have an Irish resident for the purpose of a treaty, and indeed you may end up with beneficial treatment because your investor base may have, through the relationship between the investor and the underlying asset, there may be advantageous tax treaty benefits there. So for example, where you have investors that are sovereign wealth funds or pension funds, they generally will be in a good position to obtain either domestic reliefs or indeed reliefs under treaties. So the transparent nature of the ILP can have significant benefits under the advent of, let's say, the MLI and updates globally from a treaty perspective, and that can provide a good answer in effect from a tax perspective.
Okay, great, thank you. One question that we got relates to other types of fund structures. Let me see if I can put this in some context. So the question is will the ILP replacing the other types of funds in Ireland? And I presume that they're referring to things like a public limited company, like a common contractual fund. Does anybody have any thoughts on that?
Yeah. Sorry, Dave, go ahead.
Go ahead, Michael.
Please go ahead, Michael.
Yeah, I think we saw the ICAV coming in a few years ago and largely take over from the previous PLC. The ILP has now come in, and the question is, will that replace other fund structures? I think there's still room for example, you mentioned the Common Contractual Fund, John. You'd see the Common Contractual Fund a lot with, particularly with funds set up by pension funds and others for holding assets, and I think it still will have a role there. So I think the ILP is perhaps better suited for managers looking for capital commitment type funding of strategies, whereas the CCF has a particular role, I think, in co-holding fund assets for pension fund investors in particular. That would be just my take on that.
David?
Yeah, no, I agree, Michael. And I think, John, the reality is, taking a step back from it, all of these legal structures that you mentioned the ILP, the ICAV, the CCF, the unit trust, all of them can be authorized as the quaif product. So if you're a sponsor looking at the legal structures that can be authorized as the quaif, the question then becomes, well, what is the asset profile? What is the target investor? What's the tax analysis or the tax result we want in the structure? So for example, the ILP might be better suited to invest in illiquid assets where an investor seeks capital appreciation in a closed-ended fund. A CCF would probably be more useful for a pension fund that wants to pool investments in a tax-efficient manner. The ICAV, as we chatted about earlier, might be more useful for, say, an open-ended with limited liquidity fund, investing in short-term or opportunistic investment strategies. I know from my own experience, for example, the unit trust authorized as a quaif is very popular for Japanese investors. So really, for a sponsor in the US or elsewhere, you need to take a step back, in my view, think about the asset profile, the target investor, the tax analysis. So for example, if you are speaking to that large German pension fund and they want exposure to real estate, it probably would be the logical thing to do to think about the ILP and have that legal structure authorized as a quaif. So it is, I fully agree with Michael, it's a case-by-case analysis.
Got a couple more questions. First, do the independent directors need to be Irish residents? And I guess the first question is, even before that, do you need independent directors? Because you're really talking about the general partner at this point.
You are, John, and I can take that. So effectively, that remains to be seen and is one to watch. So in the legislation, there isn't any requirement for the directors of a GP to be resident in Ireland. In fact, the legislation has flexibility. The GP can be a global entity. What the central bank has said is that any director that will sit on the board of a general partner needs to be pre-approved by the central bank. What does that mean? That's the filling out of a questionnaire, a filing with the CBI, initiative process back and forth with the regulator over typically 2 to 3 weeks before you get approved. Now, the question then becomes, okay, you've got your general partner, the directors have been pre-approved. Do any of them need to be resident in Ireland? That is a question mark, and we are engaging with the central bank to confirm that whether that is a requirement or not, but it is one to watch, John.
And
John,
is there go ahead.
Sorry, I might just come in just on that, a very small minor point at the end of that, John, is that if your GP is going to be Irish, and that's subject to what the comments David has just made, from a tax perspective, that GP itself the strong recommendation would be that you would have a majority of Irish directors on the board of the GP, just to ensure you're maintaining Irish tax residence of the GP itself. So again, once you've decided in terms of where the GP will be located, I say if it's going to be an Irish resident, you would seek to have a majority of Irish tax resident directors on the board.
Thank you, because you just answered another question about the substance requirement. So appreciate that. Another question that's come up is, does the panel expect the overall cost of operating an ILP? Will that be lower than equivalent structures in comparable jurisdictions? It's a great question.
I can give a thought on that. I mean, one point of difference, I suppose, between if we take the ILP and, let's say, a limited partnership in Luxembourg. Luxembourg offers both regulated and unregulated partnerships. So the question might be asked, would a regulated ILP in Ireland be more expensive to run, for example, than an unregulated partnership in Luxembourg? And the answer is I don't really think so, because they're both subject to AFMD. They both need the same service providers, so they actually should run on a similar cost base. And one of the interesting things is the ILP is quite quick to set up because of the regime in Ireland. So actually what you're getting is you're getting a regulated partnership structure at around the same cost and around the same speed as it takes to set up an unregulated partnership in some other jurisdictions. So my take on it would be not significantly different or at all from other EU jurisdictions.
And that, go ahead, Philip.
Yeah, and I was going to say just on that as well, in terms of I suppose the important point, and being quite, beneficial and helpful from the central bank's perspective, is that, the general partner can be set up as a simple limited liability company. It's not regulated, and as you said, there's still an open question in terms of the directors and their residency status. My understanding as well is that they are subject to the fitness and probity regime by the central bank. But from a cost perspective, I think you're generally looking at, it would be as Michael has just outlined there, probably no more and no less than say something equivalent in another European jurisdiction such as Luxembourg.
Yeah, I think one of the interesting things comparing the ILP versus, for example, the Luxembourg RAIF, it's just really a question of where the regulation is going to occur. They're both really just self-regulated entities because you have the AFM that's really doing the legwork. The question is whether or not the whole thing is being run past the central bank or in Luxembourg, the CSSF first. That seems to be the only real difference. Other than that, again, most of the regulation of the entity of the fund and its management is really all being done by the AFM.
Yeah, that's right, John, and that's the way AFMD is supposed to work. It's supposed to apply regulation across Europe on a harmonized basis at the AFM level.
Another tax question is there not a withholding tax benefit in Ireland with respect to the ILP versus other EU jurisdictions?
The ILP will generally not be subject to withholding tax in Ireland unless you have funding at the level of the ILP itself. And then, so any, I suppose, payments that are flowing up through the structure are deemed to be flowing through the structure from the portfolio to the limited partners. There will not be any Irish withholding tax on that. You would need to look at the level of the portfolio to see if withholding tax is applicable at that level. And again, you would expect that they will, at that level, you will look through to the status of the investors or the limited partners to determine if withholding tax will apply. At the level of the ILP itself, the only place you could have Irish withholding taxes, as I say, if you have funding at that level, and the funding or the interest payments are deemed to be Irish sourced interest. And again, there's a fairly broad range of exemptions that should allow you to get an efficient answer from a withholding tax perspective. And if not, then Irish withholding tax would apply. In terms of comparisons to other structures, I suppose you're looking at the Lux limited partnership structure, which is itself should also be flow through. So I wouldn't see many variations with that. And then the alternative is to look at corporate structures. And again, if you're looking at corporate structures from an Irish perspective, or indeed from a Lux perspective, they can be both regulated and unregulated. And you are looking at a stream of questions there in terms of whether or not withholding tax will apply. But generally, in a lot of cases, you are particularly from an interest perspective, you are looking at exemptions, and there are a number of exemptions there. Clearly, with regulated structures, there's an additional layer of exemptions depending on the particular payment and stream. So again, you need to look at it on a case-by-case basis, but they generally can be set up pretty efficiently, and I wouldn't see great deviations in terms of if you're looking at maybe an Irish or a Lux structure, be they opaque or transparent.
Another question is, are there any challenges in using an ILP in a master feeder structure or as a parallel fund, such as with the Delaware or Cayman fund?
I can give you a thought on that, John. So there is some challenges, all right, and sometimes with US managers looking to raise capital in Europe, you already have an existing Cayman or Delaware structure, and the question then becomes, how do you integrate those? There is the marketing passport available in Europe for AIFs, including for the ILP, which is very attractive. And one rule that attaches to the marketing passport is that the Irish or the European fund will lose the passport if it invests over 85% or more of its capital in any other non-regulated fund, or say a Delaware fund or something like that. So a pure feeder from an ILP to a Cayman or Delaware fund wouldn't normally be ideal because you'd lose the marketing passport, which is one of the great advantages for a US manager of setting up the European fund in the first place, I would say. But there are solutions to that. You can have a partial feeder where you keep below the 85% limit. The Irish fund can act as a master if you want to do that. And the other possibility would be a parallel structure where the US or Cayman structure operates in parallel. So the European structure takes in European capital and invests in the same assets. And there are a number of considerations around that in terms of co-holding investments, whether the trades are split or whether they're held in a co-holding vehicle, etc. There's a number of structuring issues around that. But typically, that's the sort of decision making that a US manager would go down as to whether it can be accommodated in some kind of feeder arrangement or whether a parallel structure is the best answer and keeping within the marketing passport.
Yeah, and you raise a great point, because one of the challenges of doing the co-holding is making sure that that vehicle, that special purpose vehicle that you set up, is not an AIF.
Correct.
And how do you do that? Requires a little finessing. But I agree, it should be possible.
Yeah, we've seen it done. We've seen that done a number of times, and you're absolutely right. There is an analysis around whether the co-holding vehicle itself is an AIF, but it can be done.
Yeah, and the idea of in the master feeder structure really just depends on where the master is more than anything else. There's no limitation on a Delaware fund investing in a Cayman fund, or certainly not. Half the hedge fund industry would be out of business. And there's certainly not a problem with a Cayman fund also investing in another entity. It's really just where that master fund is.
Correct.
Yeah, and I think for Michael's good points there, John. Oftentimes you'll see the master then being the ILP.
Yeah.
And in relation to parallel funds, that can be permitted provided it's appropriately provided for in the LPA, disclosed in the prospectus, and of course operated fairly.
Okay. Another question that's come up is, how can Ireland benefit from the lessons learned where similar structures are available in other jurisdictions?
Well, I think that's quite an interesting question, John. And I think if we look at some other jurisdictions and where they've succeeded or where they've had to change their regimes, I think one of the issues that comes to mind is, well, there's two things, I suppose. There's investor acceptability, but there's also speed to market in terms of how long does it take funds to get established and get authorized, etc. David might want to comment on this, but certainly the Irish regime facilitates the establishment of ILPs on a pretty efficient basis, which is a lesson, I think you could say. I mean, Ireland has had that regime for a while, but some other jurisdictions maybe have grappled with that a little bit in terms of allowing regulated funds to be established within a reasonable time frame that suits US managers.
Yep, I fully agree, Michael. And I think that's an important point for the audience to know, that the ILP, again, is a legal structure. It's first of all a AIF and typically a QAIF, a qualifying investor alternative investment fund. In terms of speed to market, it is subject, with some exceptions, to a 24-hour authorization process with the Central Bank of Ireland. Now, of course, there's the lead-in time for negotiation of the LPA, the material contracts, etc., which could, take 6 to 8 weeks, perhaps, or less time, depending on the stakeholders involved. But once you get to the stage of being ready to get authorized, you file your documentation by 3 p.m., say tomorrow, and you're authorized on Friday. On that basis, or authorized on Thursday. So on that basis, you do have that 24-hour authorization process, which is very attractive in terms of speed to market.
And just another point as well, just maybe to come in on that, John, before you move on to the next question. I think certainly Ireland as a jurisdiction has been looking at what other jurisdictions, again, Luxembourg, have been doing. And, in Ireland, part of the whole kind of, I suppose, the drive to grow our private funds industry is also an important point, is the real assets depository piece. And the coming, or the introduction of the real assets depository piece and the ILP is not a coincidence. I mean, I think Ireland has recognized as a jurisdiction that, in terms of, there's very significant capital flows here. There's depending on what estimates you hear and you listen to, potentially upwards of 20 trillion in dry powder available at any time. And I think from a service provider perspective, and it goes across the whole gamut from legal to tax audit and the other depository and administrators. There's a deep domain knowledge within these private fund service providers, such as ourselves and Sanne, and being able to have that one-stop shop model, which was so successful in Luxembourg, certainly is a very significant lesson learned from an Irish perspective, and one that we've certainly taken under our wing, and we're moving forward with.
Thank you. Another question comes up with respect to series, ILPs organized that permit series. Is the ILP entitled to have more than one general partner? And if so, would you structure around so that you would have a single general partner for each series, or must it have only one general partner? I think I got that correctly.
Yeah, it's a good question. I can take that. So effectively, each ILP needs one general partner. The legislation is flexible, so you could have more than one general partner, but you do need one general partner. And the nominated general partner would take on that oversight role after appointing the AFUM, for example. And the GP sits at the level of the ILP, either a standalone ILP or an umbrella ILP. So you wouldn't have a general partner per series. It rests at the level of the legal structure of the ILP.
Well, that raises an interesting question then, because in the ILP, I mean, the general partner, I presume, correct me if I'm wrong, is responsible for the debts of the partnership. So that means that the general partner is responsible for all the debts of all the separate series. In comparison, for example, in Delaware, you can have a separate general partner that's responsible only for the debts of that specific series. So are you saying that Ireland is different than from the way that would work in Delaware?
Well, it's interesting. In Ireland, the GP has unlimited liability for the debts and obligations of the ILP. Now, just to note, from a technical perspective, if there's more than one GP, this liability is shared on a joint and several basis. Now, it's also important to note that any provision, whether contained in the ILP agreement or any contract, which seeks to exculpate a GP from or indemnify them against any liability, is from a statutory perspective void. However, an ILP may indemnify a GP against any liability incurred by that entity defending itself in proceedings in which the judgment is given in that entity's favor. And also, it should be important to note that an ILP, through the revised legislation, may now purchase and maintain insurance for the GP in respect of this liability.
Okay. So another question is, are there any special provisions? We've talked about carried interest in this type of structure. Are there any limitations on how carried interest will work under the ILP?
I can take that as a starting point. So effectively, John, what the central bank did in Ireland on the 2nd of February last is introduce the ability for management shares, which would provide for a flow of carried interest, to be issued to the sponsor effectively. Now, the returns on those shares can be greater, but need to be subordinate to returns to other investors. But as a result, that does give structuring flexibility for the carried interest mechanisms, which you would typically see in a global partnership, say domiciled in Cayman or Delaware or Luxembourg. So you do have that structuring flexibility now as a result of the Central Bank of Ireland's guidance issued on the 2nd of February last.
Back to tax. Value-added taxes. Are there any issues with respect to value-added taxes in connection with the ILP?
Just say no, John, and leave it there. There isn't anything significant, John, in that a regulated fund has the ability to claim certain exemptions from VAT, and the ILP, being a regulated fund, is no different. So the main concern around VAT is that you have a VAT cost at the level of the fund that is not recoverable. And in some cases, funds will be set up, may not have full recovery. And again, there's a process that needs to be gone through to determine if a fund does have a VAT cost, what portion, if any, it can recover. This could be based on its investor base, being EU versus non-EU, or indeed its portfolio base. But for an ILP, some of the key expenses that we may see in there may be things like fund management, etc. The tax advisor fee will obviously be very small, so we won't worry about that. But the fund does have the ability to claim an exemption for VAT on those services, so therefore it minimises the potential exposure and indeed VAT exposure at the level of the fund.
You raise an interesting issue. Is there any outstanding tax or accounting issue that still requires clarification other than the VAT issue you just mentioned?
I suppose there's nothing significant at this point, but from a tax perspective, so the global tax landscape continues to evolve all the time. So again, like any structure, it needs to be continued to be monitored. And again, I'm not for a second going to pretend to be an accounting expert, because I'll get shot internally if I do, but I don't believe there's anything specific outstanding. One thing that I did hear one of my accounting colleagues note, and certainly open to correction on this, but he did note that he has not seen anything specific yet stating that you can prepare a set of separate financial statements for each umbrella or each segregated cell within the fund. You certainly can do that for an ICAV. The expectation is that you certainly can do that in the ILP as well, but that may be something that might come through as a clarification from the central bank through their Q&A function when they do issue clarification points on a regular basis. Now, David, you alluded to some of those clarification points forthcoming earlier. This may be something that might come through that, whereby they just confirm that you can prepare a set of financial statements at the level of each umbrella.
And that's a great point, because in Delaware in the last couple of years, they've really revised their limited liability partnership statute as well as their limited liability company statute to really kind of more formalize the relationships among the different series. Now with what they call a protected series and a registered series, but you can even get a good standing certificate specific to a series. So going to the idea of, more independence among the series, especially with respect to financial statements, really makes it a far more useful type of vehicle for certain types of, fund structures. Another question that's come in is, are there any issues regarding distribution into the US? Could an ILP be used in place of a Cayman fund, for example, for your US tax exempt investors? I guess I now have to work. The short answer is you should be able to use, there isn't any limitation on the ability to use an ILP to offer its interest into the United States. It would be, just treated primarily the same way that you would treat a Cayman fund. One question, though, is whether the AFM itself would have to either register with the SEC as an investment advisor or file notices as an exempt reporting advisor under the Advisors Act. I haven't seen any guidance from the SEC on that point, but effectively the investment manager or the AFM is serving in that capacity, at least, one way of reading the statute in the US. So I think that's an open question to resolve. Speaking of the AIFM, are there any third-party, a lot of US managers use third-party AIFMs. Is there any kind of special licensing that would be required for the AIFM to be able to serve as an AIFM of an ILP where they, as opposed to another type of structure?
So, John, there's the AIFMs across Europe are regulated under the European Directive AFMD, and I suppose the only point I think that's particularly relevant to US managers would be that in appointing a third-party AIFM, you obviously want an AIFM. There's two classes of AIFM: authorized AIFMs and AIFMs that are registered, which is a lower standard of approval. It's really just a registration as opposed to a full authorization. And what you want is a full scope authorized AIFM, which is going to be an AIFM with lots of substance, regulated by their local authority, with a significant amount of regulatory capital, and the people and the staff and the resources available to support your strategy. And the reason you want an authorized AIFM is because the EU marketing passport, which applies to the distribution of funds to professional investors in the EU and indeed the wider EEA, that only applies if you meet two tests. You need an EU domiciled AIF and you need an EU authorized AIFM. So you would want a third-party AIFM that is that. However, I would say that, in terms of the third-party AIFM providers in Europe, they would typically all be authorized AIFMs. So you would expect that to be met. So maybe the broader question is just in terms of the substance, the ability of that AIFM to properly oversee the asset class, and those are kind of probably the more important questions I would have thought for US managers. The license I would take as a given.
Okay.
Yeah, and I might just add to that, Michael, just one technical point to add, just to say a registered AIFM of an authorized quaif can only hold that responsibility for 2 years. So under local rules in Ireland, via the Central Bank of Ireland, a registered AIFM after that 2-year period either becomes authorized or hands over the mandate to an authorized AIFM. So that's why, again, to Michael's point, it probably makes sense, in my view, to start with an authorized AIFM of a quaif which uses the ILP structure.
Yeah, and just on that as well, I think just the other point as well is if you had a registered AIFM, I think you'd probably need to look at the individual private placement regimes. And to David and Michael's point, I mean, the fact that we've got the AFMD harmonized framework, even though there's obviously variances in the legal forms and structures from jurisdiction to jurisdiction, I think, certainly the managers that are serious about setting up European fund structures would use a full AIFM, authorized AIFM, and then when they're setting up the fund, obviously identify the distribution markets accordingly.
And I suppose, John, just to also add, I mean, some US managers would think about, will they set up their own AIFM in Europe rather than using a US vehicle? And the reason they might think of that is so that they can get the marketing passport. And that brings them into the kind of debate about resources and focus and the amount of substance that they would then need to apply in Europe, including people resources, regulatory capital, and obviously the management oversight that goes into supporting a vehicle like that, which is substantial. The advantage perhaps for a US manager in the external AIFM model is that actually you don't need boots on the ground in Europe, which is, I think, for a lot of US managers, a big plus.
Especially smaller and mid-sized managers that don't have the resources of the larger ones.
Yeah.
We're kind of coming towards the end of our hour and we want to be respectful. So ask everybody for some final words. Now that we have these amendments to the ILP structure are now effective, we have a new arrow in our quiver. How do you think this changes the landscape?
So maybe, sorry, Michael, go ahead.
Go ahead, Philip. Go ahead.
So no, and I think probably from an Ireland perspective, Ireland obviously was the forerunner when it came to the ICAV and other jurisdictions have followed suit. I think when it comes to the private funds market here in Ireland, the ILP is certainly it's a game changer, no question about it. I think you'll also see a lot of firms and other service providers coming into the Irish market because they recognise that fact. Obviously, there's the Brexit element as well in terms of, Ireland being, a common law jurisdiction, the only EU English-speaking jurisdiction within the EU now, and that's very attractive from, a manager perspective. I also think as well in terms of the connectivity routes between the US in particular and Ireland, where it's a single flight, a single hop. And in COVID times, I think when travel does resume, I think people will appreciate not having to get on multiple planes and multiple onward travel. So I think the timing of the ILP again is very significant, and it places Ireland into I think a different arena in terms of the private fund space.
We just have a couple more. Anybody? Michael, David, Brian?
Yeah. Michael, I think you wanted to add to that.
Yeah, I just, Philip said everything I want to say. I just wanted to add that I think the ILP actually hits a sweet spot in terms of it's a limited partnership structure that is going to be very acceptable to institutional investors in Europe because of its nature, because of the fact that it's a regulated structure that can actually be set up quickly in Europe. I think it's going to really hit a sweet spot in one of the main European fund domiciles. To be able to set up that structure, I think it is great. And I think there'll be a lot of people, there have been a lot of managers, I think, looking for other alternatives in Europe to set up funds for private assets in ILP type structures. I think it's going to really hit a sweet spot there.
And I'll just add to that there's as a regulated fund that'll also help in distribution outside of the EU, especially into Asia where they prefer regulated products. I'm sorry, David?
John, just to add, fully support Philip and Michael's comments. Just to say, in my view, I think it's a positive development in the European investment fund market. Just to note, the product remains the same and it has a huge investor appetite, i.e. the Quaife. That is an internationally recognized brand. There's over 2,800 Quaifes in the market, accounting for over 750 billion euro worth of net assets. So on that basis, the decision to be made on structuring a Quaife in Ireland has effectively been de-risked. There is proof of concept. What's new and exciting is that this successful Quaife regulated investment fund can now be housed in a world-class partnership structure, which is very familiar to sponsors and potential investors globally.
Yeah, well,
Brian?
Yeah, I won't add much to that, David, other than I think the overarching piece here is it's the flexibility of the structure. There are some very good structures out there in the market already. This adds, I suppose, to the Irish suite of products, and really the tax, much like the rest of the structure, is quite flexible and leaves a lot of optionality in terms of the structuring of the vehicle. For example, the ability to check the box from a US perspective obviously just continues that line the same as the ICAV. So really, from a tax perspective, I'd nearly just leave with the overarching principle that it's quite a flexible structure, and with plenty of optionality, I suppose, in terms of the way you approach it.
Yeah.
And John, I have one final thought, and I think it's quite important. All of the ecosystem that's here in place in Ireland can facilitate and accommodate the new ILP. So everything from the tax, the legal, the admin, the depository, the AIFM, it's all there. And, that makes it, in terms of its attractiveness and its ease to set up, it's a really, really key benefit.
Yeah, and the point that I would add, just sort of taking that one step further, is that for managers that already have, for example, like a usage structure, it allows them to sort of bolt on an extra piece and still having all the types of products that, investors are looking for. So it just adds more flexibility to allowing managers and fund sponsors to be more efficient in how they use their service providers and their resources.
I fully agree.
So respecting everyone's time, we're going to bring this to an end. Thank you very much for your questions. They were great questions, and we really appreciate all the participation. If you have any further questions, you now know who to call. Again, we'll be posting the video of this session as well as the video of the original session in December. We'll also be providing you a link to a presentation that will include the comparison of the terms of the ILP with Luxembourg, Cayman, and Delaware limited partnerships. I want to thank you again, and on behalf of David, Brian, Michael, and Philip, we hope that you have a wonderful, wonderful rest of your day.
Thanks, John, and thank you everybody for your time.
Thanks, John.
Take care.
Thank you.
Thanks.